said, it's not a new law, but it's still new-ish. People are still learning about it. It's actually a law that was passed as part of the Homeland Security Act, which is the law that created the Department of Homeland Security back in 2002. And what it does, to your point, is that it provides liability protection to security vendors. So if you walk around, you'll see some of the booths have a Safety Act certified or designated stamp on it, ASIS. Safety Act designated as well for its professional certifications for CPPs and others, as well as professional standards. And what it does is that if there's a terrorist event, it can limit or eliminate the liability that could flow out of that, which is pretty powerful.
Very powerful, yeah. Now, the question is, or let me go back to my law school days, IRAC, issue, rule, application, conclusion. What's the definition of a terrorist act, right? Oh, it's only one guy, that's not a terrorist attack. Or he didn't say a certain word, so it's not a terrorist attack. You know, law is slippery, right? How are we defining terrorist act to make this Safety Act work?
So that's a great question. I actually taught law school for a number of years, and Safety Act, no surprise, would often be a final exam question. So here's what we'd be looking for. The issue, as you say, what is an act of terrorism? Under the Safety Act, any unlawful event that causes harm, including economic harm, that causes injury to American citizens, American property, or et cetera, that uses weapons or other instrumentalities intended to cause an injury, that's defined as an act of terrorism.
Oh, so that's pretty broad.
Yeah, it's very broad. So again, putting back on your law school cap, you think about it, and if you go through the United States Code, which defines act of terrorism for legal purposes, this is the broadest definition of terrorism you'll see. There doesn't have to be any definitive political motivation.
Right.
Doesn't have to be religious motivation. You don't even have to know who exactly committed the event. It's just so long as that it was an intentional event that caused some sort of harm to an American or the American economy,
right?
Then it's an act of terrorism, and these liability protections can kick in.
Now, I find this interesting because if you look at the mass shootings, strangely, the FBI define, I don't know why they get to define it, but they define a mass shooting as, 2 or more people and 1.5 have to die, or some crazy definition, right? Where if anybody came in and started shooting 30 rounds, but only one guy's killed, they might not say that that's a mass shooting. It's a little bit kooky to me, right? Does that have anything to do, or do people get in court and argue that? It says, well, he was a mass shooter, but he only killed one guy, so it's really not terrorism. Do we get into all these arguments with this act?
We do, and in fact, when we talk about what happened in the Las Vegas shooting, obviously far too many people were killed. One is too many, obviously, in a situation like that, but 58 were killed. And so that's clearly a mass shooting, 800 people injured as a result of that incident. There's a dispute still ongoing, de jure, as they say, for legal purposes, but not in fact, really, as to whether that was an act of terrorism. And the way the Safety Act works, it's up to the Secretary of Homeland Security, not a court, not to the lawyers to decide whether it was an act of terrorism. It's up to the secretary to say that was an act of terrorism for purposes of the Safety Act.
Well, now hold on now. You're bringing politics into that by making him the king of terrorism definition.
Or
that's
she,
a little
depending
slippery.
on the secretary.
Or she, all right.
Yeah, that's right.
King or queen, sorry about that.
I only say that because she was a friend of mine.
Well, that position rotates a lot, so I get behind it. All right. So, I mean, we're getting into the weeds on this, because what I heard about the MGM lawsuit, and I may be wrong on this, is that MGM had said, wait a minute, I know I'm not Safety Act certified, but guess what? CSC, the security vendor on site, they're certified. And since I was smart enough to hire a CSC Safety Act certified guard company, I'm okay, I'm out of it. Not true, though. I think they lost in that argument.
So, correct and incorrect. And,
okay, that's usually the case with me, by the way.
No, you're right. MGM was, and I'm trying to be objective here since I'm not a counsel for MGM or anybody else, and I don't want to say that they did anything wrong, but they did something wrong, which is that they didn't hire CSC.
Oh, okay.
Live Nation,
which
was operating
right
the Route 91 Country Music Festival, they hired CSC.
Okay.
And so what MGM was trying to do was say that because there was a Safety Act approved company that had that was involved. In this case, they were the guards at the Country Music Festival. There should be no lawsuit. Period. Everybody has Safety Act protections.
It's not a bad argument.
Right.
I mean, I don't agree with it in spirit, because we have victims and we have to. But there's other recovery for victims. But
and then this is where sadly the lawyers come in. Okay.
Right.
We do. We have our role to play. And the issue was for the claims related to the Safety Act. What did CSA do? They were the guards at the facility where the shooting where the bullets went into. Okay, and so they're responsible for protecting the concert goers and mostly for evacuating them during the shooting. MGM, however, they were the location from which Mr. Paddock shot 58 people, not even allegedly. He did it. And CSC was not employed as guards at the hotel. So MGM's liability doesn't really stem from what CRC did or did not do, or what Live Nation did or did not do. It stemmed, allegedly, according to the plaintiffs, from what MGM did or did not do. Why was he able to amass a large arsenal, quote unquote large arsenal, in his room?
Kind of a different
week?
lawsuit.
Yeah, exactly.
Yeah.
And so in that particular case, what the question was really about was, did MGM do something wrong? Nothing to do with CSC. So CSC and Live Nation, they could argue, well, the Safety Act protected us, but because we had no contractual or other relationship with MGM, it's up to them to figure out whether the Safety Act approved and automatically applied. And I think a lot of people would argue that MGM doesn't really have a legal argument there to take advantage of the Safety Act.
That's very interesting. I mean, I could see why they would try to take advantage of that or tie it into it, but it's a separate facility. This almost seems like a case of first impression.
It actually is.
Yeah.
Yes, this is the first time that the Safety Act has been tested in court. It's not the first time that it could have been tested. There have been a few other incidents where maybe or maybe not it could have been involved, but this is the real first test of the Safety Act in court. And it's been interesting how it's played out, if you want to talk about that, which is that what I find really interesting is that MGM is heading towards a settlement with the victims of the shooting. And if you read their statements to the Securities and Exchange Commission, they said that they're anticipating paying out about $800 million in claims payments to the various victims of the lawsuits, which, we can talk about whether that's appropriate or not. I don't make any judgments. Sounds right to me, but what do I know, right? I'm just a simple country lawyer from backwater D.C., right? So, but, with respect to CSC and Live Nation, they were originally sued, but their claims were then dismissed. The plaintiffs dismissed the lawsuits against CSC and Live Nation. And, those aren't two small companies that are judgment-proof, right? Especially when you start talking about Live Nation. That gives you a really interesting perspective that even though it's still an open issue as to whether the Las Vegas shooting counted as terrorism, the Safety Act was a very powerful factor at the end of the day in deciding who should we be going after and who can really take advantage of this liability protection.
Now, I get the deep pockets thing. They got $1 billion there at MGM, but under the Safety Act, Live Nation and CSC weren't indemnified completely. Their liability was limited, right?
It would have been, actually, because CSC is what's known as certified, it would mean that they don't face any liability relating to the alleged performance or non-performance of their security
guards. Oh, so they're indemnified kind of thing.
Yeah, well, indemnify means that the government would pay their damages. Yeah. No, in this case, they would have been able to dismiss the lawsuit against them. And then Live Nation, as a customer of CSC services, can say, look, don't sue us for anything CSC did or did not do or was within their control. You can't sue us for that. So we hired the wrong guard company, they were negligent, etc. That all has to be dismissed. Instead, those claims only can be brought against CSC, which can then dismiss them. So, for TV viewers out here who are thinking, well, why would I care about buying something that's Safety Act approved? If you buy a Safety Act approved barrier or explosive detecting canine company, and something bad happens at a later date, you're going to get sued. Everybody gets sued afterwards. This is a great way of saying, hey, you can't bring a lawsuit against us because we bought something that was Safety Act approved. And so at least for that barrier, for that dog, those claims were out of the lawsuit.
Right, so that's why I wanted to make sure there's this line drawn. So I go buy the Safety Act approved turnstile. I'm doing my research. I'm responsible corporation. I now am behind that shield to some degree.
Correct.
All right. At the same level as the company itself that's certified?
It can actually be higher.
Really?
So interestingly, if, let's say, the turnstile is what they know is known as designated, meaning that the turnstile manufacturer can be liable, but only up to their insurance number. Let's say $5 million, $10 million, or whatever. The purchaser of that turnstile, this facility or sports stadium or an office building, they still don't face any liability. So it doesn't matter with respect to whether it's designated or certified. They, under federal law, are not a proper defendant. Only the company that actually sold the turnstile is the proper defendant in the federal lawsuit.
Now, I think that is fantastic for corporations, and I think it sucks for victims. So let's go the other way with it, right? Because now these poor victims, maybe, let's say everybody at MGM had all those acts. MGM was certified, the Guard Company, Live Nation was certified, the parking attendant was certified. Where are they going to get money from? How are they going to recover? So I think we need to address that, and there are some other avenues. Let's talk about that.
Right. So that's a great question, and it's a fair one, and that's the debate Congress had and the president had back in 2002 with the Safety Act. And the first balance there was, look, do we want to have a situation where the only recourse for somebody who potentially is or actually injured in an act of terrorism is a lawsuit afterward? Don't we instead want to encourage these really good technologies to be out there?
That's a good point.
Okay.
Yep.
So that was the balancing test that Congress came up with and agreed to the Safety Act and said, look, it's limited liability protections. We're not eliminating liability for everybody who is involved in the lawsuit. It's only people who have a definitive contractual relationship with the Safety Act approved company. And in the case of the MGM lawsuit as it's currently playing out, MGM still is a pool of resources. Theoretically, if you get to a point where everybody in the universe that is potentially touched the event is in fact Safety Act approved, then yes, you've significantly narrowed the universe of people from which they can recover. Doesn't prevent, however, for instance, administrative or criminal liability in that particular case. So a state or the federal government can still impose a penalty and reimburse victims that way. Doesn't cancel insurance, doesn't prohibit the U.S. government or a state government from creating a victims' compensation fund. What we're really saying here is that DHS has come in proactively and said, your technology is so good and so effective, we want to see it out, and because of that, we're going to limit your worries about liability. And if you're designated, which is the majority of the Safety Act awards at this point, it's up to your insurance. So you have a better handle on what your exposure is versus this world where, a hot cup of coffee is a $4 million spill, right, or something like that, and. So there is definitely a balancing test. Yes, victims may have less options than they would otherwise in a plaintiff free-for-all. But look, we also live in a world where tort reform happens all the time. There's lots of states that have tort reform caps. They have malpractice caps, et cetera, that type of thing. So this is another example of that. But in the case of terrorism, where post 9/11, there was a significant worry that responsible companies were not going to sell anything, or they weren't going to sell them to riskier markets because they said, we don't want to go bankrupt. We don't want to expose ourselves to that liability. We'd rather just stay away. And that ultimately, I would argue, in the grand balance, is a net negative for the country.
All right, I got a tricky law school question for you.
Go for it.
I'm certified. I got my turnstile company certified, and I have some indemnification. I have some insurance protections. Before I had that, I tried to do what? Not be negligent.
Correct.
Right?
Yep.
So negligence is act or omission, duty, breach, causation, damages. If I hit all those 5 things, I can sue you and hopefully recover, right? Now, if I'm insulated to some degree with the Safety Act, I'm just going to sit back, I don't care about negligence anymore. I'm just going to put that thing in my turnstile. I don't care if it works, and I'm protected and everything's good. And so now I'm getting legally lazy. I can see where this might lower people's performance on those things that are important in negligence, right? Because I'm kind of shielded. What do you think about that?
So first of all, thank you for not including any math in that question. It's always been my understanding there's no math involved in the law, and so that's a good thing, and my math grades prove that. With respect to your negligence question, it's a good one. And the short answer to that is that if you go in with the mindset that we're going to get this protection, but then we're going to step back and we're not going to maintain, we're not going to train, we're not going to continue to vet our employees.
I can save money not doing those things, right?
Exactly.
Yeah.
That will negate your Safety Act award.
Oh, good. All right.
So,
well, not good, but you know what I mean.
Yeah.
Right.
So if you submit an application with false information or you willfully mislead the department, then your Safety Act award can be nullified.
Willfully I get, but let's just say you're just, listen, I got to save money this year, and we're cutting out all the negligence training. We're cutting out whatever those things are.
Right.
Not because I'm malicious. I'm just trying to save money, and I'm not very smart. It's got to be intentional, you're saying.
Yeah, it's
Probably.
got to be intentional. And so, this is, unfortunately, I hate to say this, but, it'll play out in court.
Yep.
Judges are very powerful, especially federal judges. They can kind of do what they want. They do have lifetime tenure, so they don't really need to worry about these things. And they may find a way to say, we understand, willfully misleading in this case might also be, well, our plan is to do this unless we want to save money. And so that could be an argument. If I were trying to circumvent the Safety Act protections, one thing I could say is that I represented to DHS in my application that I was always going to have the training. I was always going to spend a certain amount, et cetera. And then I didn't include in there unless it's a bad year. We didn't have a good Q3, and so we're going to cut back on that. You can make an argument for sure that was misleading the department, and as a result, your Safety Act award should be negated.
Can we say that this has created two standards of care? I got the Safety Act certified people over here. I got you lower, not Safety Act certified people over here. This is a lower standard of care. You should be on this higher standard of care, and therefore now I have more liability on this side. I don't know.
It's a good question.
I try to ask the good questions.
I like the way you work. I should have you on my team. So, let me know what your hourly rate is. So, but like it is a good question, and the short answer to that is you can't necessarily read everything into not having Safety Act protections.
All right.
No one is guaranteed getting Safety Act protections. Right? It's a voluntary program. There are any number of reasons why you might not get Safety Act protections.
But it is saying if you do get it, it is saying you have a higher standard of performance, care, technology. You're the best of the best.
It's saying you've demonstrated to the Department of Homeland Security that you are effective and useful in deterring or defeating an act of terrorism. It doesn't mean that you aren't just as effective as a non-Safety Act
company.
That's
fair enough. All right.
You actually have proven that to DHS. And so a company that may decide not to pursue Safety Act protections for a variety of reasons. Number one, they think, well, their liability is not that big to begin with, so why bother to pursue this? There are other companies who say, I just don't trust the government. I don't want to give them any information about it. So I think, to your point, really, if you're looking at a company that is Safety Act approved or not Safety Act approved, it should lead you to ask additional questions as to why haven't you done this? And there may very well be a reasonable and well thought out response to that as to why they didn't pursue Safety Act protections, and that's where it needs to go, as far as I'm concerned. But it's like anything else. If you know what you're talking about and you know the benefits of the Safety Act and what it can deliver and what it can't deliver, go ahead and ask, do you have it? If you don't, why not? And you may get a good answer.
Does the Act guard against internal negligence? Here's what I mean. I got company over here, I got DHS over here. We're doing the certifications falling down the middle. We're analyzing. We're saying these guys are good. We're going to certify them. But me as the guy that did that screwed up. I didn't do my job. I threw things in the wastebasket. I didn't fill out the right form. I didn't certify them properly. Can they be internally negligent? The government be negligent in issuing the certification and therefore defeating the act somehow? I mean, the guy really just said, "Oh, he's a buddy of mine. Let's stamp it approved," and it was totally bogus.
Interesting. Again, that's where a court would come in at the end of the day. And so what you're really going to do is you're going to, in the beginning part, you're going to ask, well, should this have been approved? And it's really going to go to the false or misleading defense.
Well, it's also kind of negligence because I'm just a lazy employee and I don't want to do it, right?
Right.
Yeah.
Yeah. That's an interesting one. You could probably sue for on other grounds against the U.S. government, try and get a recovery for them for what you could have received from the private entity for those hundreds of millions of dollars. There are avenues by which you can pursue claims, and the government gets sued on a daily basis for those types of claims. So that's potentially where it will come. I would say, especially if someone from the Office of Safety Act Implementation or the Department of Homeland Security happens to watch this program, they do a very good, very thorough job. They are model government employees. They have won awards from the Secretary of Homeland Security. They do a very rigorous job. So I think the possibility of that is extremely low, but it's a fair point to raise and say what happens in that particular circumstance.
Fantastic. Now, we got some questions out here in the audience. I bet we do. Come on, don't be shy. All right, where's our mic? Here we go. Yes, sir.
Thank you for an interesting discussion. So, I haven't followed this case very closely, but one issue that I think is interesting is that you have a complex series of events here. You have the Live Nation and the Harvest Festival on one hand, you have an adjacent hotel on the other hand, and normally the two wouldn't necessarily be connected per se, but because of the confluence of events, you have this mishmash of liability, if you will. So, to what extent would you comment on the fact or the possibility of the hotel being negligent for doing something that most hotels don't do, which is screening a passenger's luggage prior to them checking in to prevent the introduction of weapons into the hotel room?
Yeah, and I think it's a difficult situation. Again, not being a lawyer for MGM, so I can't know exactly everything that's gone on. But yeah, you're right. I mean, especially in Vegas, what's the mantra? What happens in Vegas stays in Vegas, and especially in the hotel rooms, right? And so it is not industry standard, particularly at that time, to check in on guests and review their rooms, etc., for firearms. And I think they could have very easily made that argument. Why they didn't choose to do that, I don't know. I understand there was also a similar matter, not obviously in the same scale, that happened a few years ago, which may have led to greater possibility of liability on behalf of the hotel. So it really goes to the mindset of MGM of, did we think there's potential exposure here for us based on the facts as they were presented? I would say going forward, we have heard of a lot of hotels and entertainment venues that are doing more with respect to investigating rooms, in that they are now training cleaning staff, for instance, on taking a look in rooms, and if they spot something very unusual, a number of firearms, etc., that type of thing, having that report to security and making clear to guests that the hotel reserves the right to inspect a room. So it's it's a challenging point, and I would say just very briefly, it's interesting too, because a lot of this liability arose out of 9/11 and actually the 1995, or excuse me, the 93 World Trade Center bombing, where there were lawsuits in 93 against the fertilizer manufacturers for creating a product that could be turned into a bomb. Everybody knows fertilizer can be turned into a bomb when mixed with fuel oil and that type of thing. Courts in that case said, no, we're not going to hold the fertilizer manufacturer liable. The bombers were responsible at the end of the day. And terrorism was unforeseeable. Same thing in 9/11. The defendants came in and said nobody envisioned that terrorists were going to hijack a plane. For the Oklahoma City bombers, in those cases, they said, you're right, we're not going to hold the fertilizer manufacturers liable. But for 93 and 2001, courts did come back and say, we are going to hold you liable because it was foreseeable in the case of the 93 World Trade Center bombing. They actually had a risk assessment that specifically spelled out someone putting a car bomb in the parking garage of the World Trade Center. And then in the 2001 timeframe, it was just a different area, and the court said, you know what, it is reasonably foreseeable, potentially, that someone could hijack a plane, so we're going to go and litigate this out.
Another question. Here we go.
Thank you. So the Safety Act protections are triggered in an act of terrorism.
Yes.
So that could get very political in what is an act of terrorism, as opposed to just a mass casualty incident, correct?
Yes.
So who makes a determination?
It's the Secretary of Homeland Security who makes that decision.
One person.
Yeah, one person. Now, there are some people who say that potentially a federal judge might be able to make that decision. That is what MGM actually is thinking about, and they actually brought a lawsuit asking a court to declare that an act of terrorism has occurred.
Has it been decided yet? Not yet.
It is not.
Okay.
It is, in part because they're in settlement talks.
Yeah.
At this point. And so it's really, that's an outstanding point. We still don't know, but under the statute, the way it's currently interpreted and the way things are currently being implemented, it's up to the secretary alone to make that decision. And you raise a great point. We talked about earlier, this is the broadest definition of terrorism in the U.S. Code. So basically anything could, cyber, physical, all that can be declared an act of terrorism. It's up to her or him to make that final political decision.
Another question?
Hi, Chandra Seymour, Marchers Consulting. Following up on his question, it's my understanding that to date we haven't had any event that's actually been declared a terrorist event. Is that accurate? Like even the Boston Marathon? And so if that's not in play, does that now negate all the protections?
So, again, another good question. We got a lot of good questions.
A lot of good
Sam.
questions,
I love it. There are people who will say, well, if it hasn't been tested, then why would we go out and pursue this? Again, a fair question, but if you look at what the investment is in terms of pursuing Safety Act protections and the potential liability protections it offers to sellers and purchasers of anti-terrorism technologies, I think it's a question of, is this investment of time, is it the return on it at a later date, is it worth it? And considering that it can dramatically limit or eliminate your liability, and it can reduce litigation from 15 years in the case of the 93 World Trade Center bombing. The decisions, actually, it was close to 20 years at the end of the day. Those lawsuits are going on. That's a lot of money. I would have a lot of partners who'd be very happy to take a case that would last 5 years, much less 15 plus years, right? So would I. Got 3 girls heading off to college, so I'm not encouraging anybody to sue, but point though is that those potential reductions are very significant at the end of the day, and honestly, everything comes with a risk, even insurance. How many of you have ever had to fight with your insurance company? The answer is everybody. At some point, was that water leak covered? And now in cyber insurance, the people are arguing whether a ransomware attack was an act of war and thus excluded. So there's always a risk with everything that you're not going to get what you paid for. And again, so you look at it and on balance, can this be really significant? And I think to really answer your question, I think we see the Safety Act proving itself in the MGM lawsuit, even though there wasn't an act of terrorism declared, number one. Number two, the potential for it is really significant. So if you are pretty strategic about your risk management, it's something you'd look hard at pursuing.
Can I take another question? Here we go. What's our time? About 5 minutes? 3 minutes? Okay, last question. Go ahead.
Are you aware of other safety acts in other parts of the world that are similar, or do you think this is just a case of litigation in the US driving this particular change?
We in America are exceptional in our determination to sue anyone and everyone following an incident. So I have relatives, they're not my mother-in-law, but they may be my mother-in-law, who have threatened lawsuits for slipping on something at the grocery store. We see these lawsuits all the time, and that is our judicial system. Right or wrong, it's I think on balance it's a pretty good one at the end of the day. But we are we have a judicial system set up in our Constitution that is designed to compensate victims via litigation versus some pretty dramatic punitive administrative penalty regimes that are set up in civil law countries like Japan and Europe and other locations. So the Safety Act is unique to the U.S. There have been discussions about pursuing it in Europe and other locations. To date, that has not happened. So right now it's U.S. only. But I should add, though, if something happens overseas and it affects an American and the case is being decided under U.S. law, the Safety Act can still be applied.
The Safety Act and the MGM lawsuit here at GSX 2019, live from Chicago. My guest, what's your name one more time?
Brian Finch.
And the website?
PillsburyLaw.com. Don't look for the cookie, look for the lawyers.
Fantastic. Back in here at GSX 2019, live from Chicago on SecurityGuideTV.com, SecurityGuideRadio.com, and ASISTV.org.